and we're happy to have you with us. This morning, we're going to be talking about making a valid will in the state of Texas and just what that requires. So I'm shocked on a daily basis at the kinds of wills that people will bring to us that they tried to do on their own, or they took a form from a friend, or they had a lawyer who was related to their niece's brother's cousin, and so they did it that way. And so it's really an area where it's worth making sure that somebody who knows what they're doing prepares it for you, reviews it for you, because you get one shot, right? So when you die, whatever will you have is what is going to control your property, and it's not, I know sometimes people are scared of the expense, but gosh, to work your entire life and not make the investment to protect what you own and making sure it goes to the right beneficiaries is a mistake, a serious mistake. So anyway, today we're talking about how to make a valid will in the state of Texas. I've titled it, Does My Will Need to Be Notarized? Because a very common mistake we see people make is they write out their will and they're like, oh, I got it notarized. Is that effective?
Yeah. So first thing when we do those kind of wills is it's supposed to be what? Holding in your handwriting. So as soon as you get it notarized.
Not in your handwriting. Right. The overall way to make a will in Texas, there's two options. And we're going to talk about one of the options primarily today, but want you to be aware, and we'll do videos in the future on it. But there's two ways to do a will in Texas. One is handwritten or holographic. And Chris, tell me how I would do that.
Yeah, so literally I get a piece of paper, preferably a piece of paper. I've seen on the back of cereal boxes, but a piece of paper in my handwriting. I'm going to clearly write it's my last will and testament. I'm going to write out that I clearly have the intent that when I pass away, I am giving the things I own to certain people. I will have a residuary clause for everything I didn't specifically list. So anything I forgot to say, my car, my favorite, lawnmower, whatever it may be, I have a residuary, a catch-all, and I'm going to name an independent executor because I want to make their lives easier. I'm going to, sign it. I'm going to date it. And I'm going to regret doing it all this way and wish I had done it a better way. But if I had to do that because of whatever reason, that's what I'd start with. But
right. So
then I'd have an attorney. I would not. I cannot recommend doing a holographic will. They are wrong all the time.
Yeah. Well, and just you left things out. So if people do it, we previously did a video during COVID where maybe it was hard to get out, or maybe for whatever reason this is just all you can do. We want you to be able to do it correctly or as best you can, but it's really not recommended. But that holographic will in your handwriting cannot be notarized. That is not what makes it valid. That in fact invalidates it. So if you've done a holographic will that's just in your handwriting, it's just you. That's it. That's all you need. You and your handwritten will. When you die, for somebody to probate that, they've got to bring a handwriting witness, an expert that says this is their handwriting with them to court to prove up that will. So we've added some additional, hurdles for whoever you're leaving in charge there. But that is a valid will that can be admitted to probate to effectuate your wishes. So that's not going to be what we focus on today, but that is one option that we'll probably do a video on in the future.
I've seen multiple people attempt to do that. Mm-hmm. I've seen siblings write out the will for their brother or sister and then have their siblings sign it. And I'm like, nope, it has to be in the handwriting of the testator, the person who's writing the will. Those just make me very nervous.
Yeah, absolutely. Easy to mess up. Option number 2 is what we call an attested will. So that means that you have put in place something that clearly indicates it's your last will and testament. Usually you should do so by saying, this is my last will and testament. And you have signed it in the presence of 2 witnesses that are over the age of 14. That is what prepares a valid will in Texas. So of those 2 options on how I've created a valid will, is a notary needed for either of those? No. Now, a notary may be a great idea because we'll get into talking about how to self-prove that will, but an attested will just means I have created my will, indicated that it is my last and final wishes. I have signed that will, me being over the age of 18 and of sound mind, in the presence of 2 witnesses who were over 14, and they also signed the will. That's all that is needed to make a valid will in the state of Texas. Now, when I go to probate or my executor goes to probate that will, I've created some additional hurdles for them too, because they've got to bring the witness or sworn testimony of a witness that signed my will to court with them after my death to prove that will up. Now, if I signed that will 30 years ago,
Yep.
wow, it's going to be pretty tricky to find one of those witnesses.
Some of the courts are very strict on that. So you are creating hurdles after you're deceased. So definitely not what I would do either. I'm going to do it the whole way, the right way, the entire time.
Right. So is a notary necessary? No. But why would we use a notary, Chris? How do we use a notary?
So we have a notary. The notary watches everyone sign in their presence together. The notary signs, the witnesses sign, the testator signs. There's an affidavit that's attached. It will allow the will to be self-proved. It allows us to go to court in a much smoother fashion. Do not need the witnesses.
Right. And that's called a self-proving affidavit. It's statutorily created, and it is one of the common mistakes that people make when they are trying to do a will on their own. So if you have downloaded or used online software to create your will, one of the biggest hurdles that you have is correctly executing that will, because you have to sign in the presence of the witnesses and the presence of the notary. You cannot create your will, sign it, run it to a neighbor, get them to sign it, run it to another neighbor and get them to sign it, and then get it notarized at the end. You have to do that all in a formal ceremony where everyone appears together. And the self-proving affidavit, I did actually want to read you what is statutorily required, because this is one that people mess up a lot. It is not as simple as just saying testator signs, two witnesses sign, notary signs. There is a recommended, you can make it substantially similar, but there is language in the Texas Estates Code that is required when you are doing or using a self-proving affidavit, and that's in...
And every state has their own probate code, their own estates code, so every state's going to have different requirements from this part.
Absolutely right. This is Texas only, but the Texas Estates Code requires under Section 251.04 that a self-proving affidavit state in it that the testator, which would be you creating the will, is over the age of 18, appears to be of sound mind, and that those witnesses are age 14. Failure to do so means that your will is not self-proved, and then you're back to your executor has to bring a witness with them to prove up your will. So having a correctly done self-proved affidavit is an amazing tool in Texas, because if you've left for your executor the original will where they can have access to it and use it to probate at your death, and it's self-proved, well, you've made it as easy as possible for them to get that job done. Yeah. Is there anything you want to add to that?
No, other than the part where you said original will. When we talk about problems here in a few minutes, I've seen many, many people show up with copies or pictures or photocopies or faxes, and I'm thinking, let's sure find that original will. It would make life much, much easier for the executor.
Right. Well, and part of the, I think, misunderstanding about that is that people often think once they've put a will in place, that's what means they don't have to probate. And they fail to realize that having a valid will doesn't transfer title. It makes no transfer of title or ownership. It states what your wishes are, but that will has to be probated within 4 years of your death for it to have any legal validity. Yeah. Your executor is not the executor until it's been probated and they've been appointed executor, and you are not the legal owner or beneficiary under the will until that will has been admitted to probate by a judge after your death.
So, in other words, your will has no effect, no meaning whatsoever unless your executor takes it to court within 4 years of your date of death. I've seen more surviving spouses run into this problem, since I'm jumping ahead on problems, but I've seen more surviving spouses. If you're a blended family, you've been married 50 years, and your husband has a child from before marriage and left a will that left you everything, you must probate that will, or 1/2 of the community property estate belongs to his child, which means the home and y'all bought together. You would keep your half, but his half would go to his adult child or children. And with a separate property, it's even worse. So if you have a will, you need to see an attorney to make sure that you cover what needs to be probated or not. The right answer is to always probate the will. I mean, that's always the right answer. Whether it's necessary, it might be a different issue, but you want someone other than your opinion on this matter to give you advice.
Right, absolutely. Step 1, valid will. Step 2, when someone passes, make a determination about whether you need to probate, but err on the side of probating the will, because that's how you protect your interest in it, for sure.
Oh, gosh, yes. Yeah. Just scares me. Too many of those just sitting on. I have this will, I'm like, oh, when did your loved one died 6 years ago?
Yeah, just real briefly. I mean, you just kind of talked about it, but let's say I have no will.
Okay.
What happens?
So if you have no will, don't worry. The state of Texas will write one for you. The state of Texas will divide your property up between property acquired before marriage and property acquired after marriage. Property acquired before marriage will be separate property. It'll divide it up between personal property, which is stuff, and real property, which is land. It has different rules on how it's divided. Surviving spouse usually gets a life estate. The rest of your property is community property, things acquired by both of you during marriage. Think vehicles, houses, the contents of your home. Well, you in Texas own one half of the things you purchased together. Your spouse is deceased, own the other half. And when you passed away, when your spouse passed away, their one half interest, if they had no will and did have children from before marriage, would go to their children. That's the one that scares me the most.
Well, it's really unfortunate that only about 50% of adults in America have their wills done. And it's really, a failure, if you think about it, to have spent my entire life working to build whatever wealth I have, and that doesn't mean financial. That could be just your home and your car. Those assets are important, and we want to make sure that those are sent to who you want your beneficiaries to be with as little trouble as possible. And it is, in the grand scheme of things, the cost of having a correctly prepared will is worth more than so many things. So just taking the opportunity to put that will in place and not let Texas write it for me, plus making sure that I've done it correctly, and it's so important.
And when Texas writes that will for you, it's a process. It's an expensive, long process that a normal, easy probate would have been quicker and cheaper. If you had a good will that's properly done, you're going to be in and out of the courthouse, your executor would be, way before the determination of heirship and all that's done with ad litem attorneys, notice to heirs. I mean, that is an unpleasant process. I've seen many devastated families who lost a loved one who then go on and lose property that they didn't understand was theirs.
Absolutely.
That was never theirs.
Yeah, I was trying to think of a example, kind of, of other times when people try and do things on their own and they, get by with it. So maybe, you file your own taxes and you use TurboTax every year and you think, well, I don't need a CPA. This is something I can do on my own. So why can I not do this with a will? Why can I not get online and use LegalZoom or any of those other online things? So Chris and I just want to give you some examples of mistakes that we see people make trying to do that on their own daily. And the problem is that when I file my own tax return using a system, well, I'm still alive to get the IRS response if I've messed it up or not. You have the opportunity to fix it. The problem with your will is nobody's going to know you messed that up until you've died and your kids or your beneficiaries are dealing with that problem. And if you left them no valid will at all, you've really seriously messed up. You've left them a hot mess and they are paying to figure out how to fix it. They may never get some of your property. So it is crucial that you take the time and invest in making sure that you have done this correctly. This is not one to gamble on, is all I'm saying.
Yeah, some common things that I've seen or talked to other attorneys about. One of my favorites is it says, hey, I leave everything that I own. And then on those pre-printed forms, they'll have blanks. They'll have like line 1, line 2, line 3. And on it, they'll list, John, Mark, Luke, right? John, Mark, Luke listed. The problem is they left off Matthew and James. So first off, Matthew and James are out. Then the next question is, okay, you've got 3 people listed. Does everything go in 1/3 equal shares, or does everything go to the first child listed 100%? I've had that question asked multiple times, and every time they asked me, I said, well, I don't know.
Yeah.
I don't know. And the only way to find that out is when we take this ambiguous will to court, is to go before the judge. And all the children, well, at least the ones listed, I would think, are going to show up. The unlisted children are really going to be mad. So I don't know if 100% goes to the first person listed or if they're equal shares. And ultimately, the judge of the county where you died will be making that decision. And that will be a very expensive process. And clearly not everyone's going to get what they think they're getting. I've seen that multiple times. I've seen these typed out wills and people handwrite names like other children on the back. I'm like, I don't know the legal effect of that other than thinking I wouldn't want to be a kid on the back page. That's not promising. Other ones I've seen people bring in or have talked about or heard about that have scared me a bunch is they'll have these wills and they'll say, I leave my house to my wife, and then they'll take the pen and scratch out everything else. Well, I don't know anything else.
Right.
You do your residuary. What about the lottery you just won, or the wrongful death claim where you got accidentally killed by a semi truck, and some great attorney has sued on your behalf? And where does that go? You have no residuary clause. You've eliminated that. Or what if your spouse is deceased? What happens if you named your children and they're deceased? Does it go to their kids? Does it go to the other surviving children? I have seen all of those mistakes where either it's not explained in the document, or it's been removed by the person doing it. It's a poor document, or we made poor decisions. People love to get their pens and start editing these things. Is that edit done at the time of execution? Was it done later? Does it have the same formalities? I mean, there's some real questions start going on there. Every time I see an edited will, my favorites is when they actually cut out or scratch out the underlying words so we didn't know it was there. Yeah. I just see these things in my head. I said, headache, expensive, and trouble. That's what's coming.
Yeah. Absolutely.
Don't do that. Don't do any of those things.
A residuary clause will give you kind of a list of things to think through as you're getting ready to make a will in the future, but your residuary clause is somewhere in your will, there's a pot or a bucket, and everything remaining in your will that you didn't already specifically list to go to somebody needs to add up to 100%, and you need to say who gets it. That's, I would say, the most common thing that gets messed up in wills that you try and do on your own. Because if I were, just common sense thinking about it, I'd say, well, I want my stuff to go to my spouse and my kids. So in the residuary, I'd say, I want my stuff to go to my spouse and my kids. Well, the court is trying to determine what the testator's intent was. So I can only, under my will, control what I own. I own half of my community house. So if I said that half goes to my spouse and my kids, well, now my will says that goes to my spouse and my kids equally. As opposed to, one thing that people just don't think through very well, I think, is one of you is going to die first. You are not going to die at the same time. One will die first and one will die second. And your will needs to very clearly address what happens in both of those situations. So my will should say, I leave everything to my spouse. In the event that he has died before me, then I leave everything to my kids. And I want his will to say the same thing. If he dies before me, I want to own his half of the house. I don't want his half of the house to be owned and shared by me and the kids. My kids are minors. That would infinitely complicate my life if I wanted to sell that house. So the residuary is so important, and people list multiple people, like you've mentioned, making it not clear. People will say, and I think it's because they give you several blanks, so you just fill them all in, right?
Right there.
Yeah, and sometimes people misunderstand what they own and think that their spouse will automatically own the house, so they just say all to my kids. Well, you got to say spouse first.
Mm-hmm.
If in fact you want your spouse to get it, you do have to say everything goes to my spouse. If spouse is gone, then to my kids. So there needs to be a clear delineation between first, and then if that person is gone, then what?
Yeah, I always love it when I read one that says, so I have a trusted son named James. I am going to leave everything to James as my executor to distribute per my known wishes. And there's no known wish in the will. I've seen a couple examples of those, and I'm like, well, that's a problem. So these wills, while they're not necessarily complicated, they need to be correct. I've seen, I'm not even talking about the poor handwritten ones. Those are always disastrous. But even these are the ones where they'll show up with little logos on them and stuff, and I'm like, oh no. When I start looking through it, usually those have significant problems. And you're hoping that the kids will cooperate with each other, because if not,
right.
Everything is going to be lost to cost.
Your will needs to be legally clear. Yeah. Whether it's clear or not to you is not sufficient. It needs to be legally clear to the court that's going to make the determination about who you're leaving stuff to. And 99% of average people would not make a legally clear will when left to their own devices to write those things in. They just wouldn't.
What if someone shows up with two wills dated the same day with the same witnesses? Everything's almost exactly the same. I've seen this scenario before. I've had situations where people may show up, siblings will show up with each of their own copy. They're actually both originals, but they're slightly different from each other. And then I'm looking at, so the question is, which one was executed second? Is what we're trying. Problems.
Yep.
This is why you probably should go through a lawyer.
Right. It's worth the time and effort to go through a lawyer to have it done correctly. We don't want to have joint wills. A lot of married couples will assume that they can put one will in place for the both of them. No, you cannot, or no, you should not. Yeah, that is another back to one of you will die first. That person needs to have a will that says clearly what happens at their death, and then you can follow that up with a remote beneficiary clause that says what happens when both of you die. That's fine. It should be addressed in both of your wills, but you should have separate wills.
Absolutely.
Yeah. No joint wills.
Absolutely. No joint
Yep.
wills.
So-
Contractually, joint wills, no.
Yeah, one of the other mess ups that I just routinely run into is messing up the self-proving affidavit. So folks that try and do it on their own will have the testator sign, the witnesses sign, the notary sign, but will not include that the witnesses are over 14, or will not include that the testator was over 18. And those things are required. So if I've messed that up, then my executor has to bring with them one of those witnesses to testify at court. And that gets increasingly harder because if you had a witness maybe that you didn't know well, maybe you took it to the bank and got it signed, how in the world is your child going to find that witness later? We're just building in problems that will make it harder for them, if not impossible.
I've seen a bunch of times where, if it's a married couple, at least one spouse understands what we're saying, right? They understand that they need to get this done. And I hate to say it, but it's usually us men who don't want to get this done. I think the secret to that is us men just plan on dying first and not being our problem. Right?
Yeah, true.
That might just be what our
I
thought
agree.
process is. If you are the surviving spouse, or you are the spouse who may be the surviving spouse, and you're in a blended marriage, or really just if you're married, you need to drag your spouse down by hook or by crook and get it done. I tell them all the time, I don't know what your spouse is going to do. Maybe your spouse is going to leave everything to his adult children or his children from before marriage.
Better to know.
Better to know than to find out you're half as rich as you thought you were. I have seen too many devastated surviving spouses in that scenario who already lost you and now are losing a lot of things they thought were theirs.
Yeah.
And it is a double whammy they're not prepared for.
I think actually most, and not everybody, but I think most spouses, if asked, would say, well, yeah, I want my half of the house to go
Of
to my
course.
spouse to stay there, right? And they don't realize that Texas law would not automatically make that happen because you bought the house together, you're both on the mortgage, and if you have failed to put that in place, you have left them just in a somewhat, really catastrophic spot. So make sure you have a valid will, and ask for it for Christmas.
Yeah, you just have to get it. You have to hook it by crook. You get it and get it done. And then, of course, if you did all that, if you got it done, make sure that you consider probate within 4 years of death.
Right.
That one is just an easy one to let go. You're upset. You're emotional. You already got the will. Everyone's getting along, so you think you're done. And that is not the case. The will has to be presented in court in the correct manner. So don't do all that to fail at the end. There's multiple times I've seen people in court trying to find ways around the 4-year restriction, and it can be disappointing.
Yeah, and we want to give you just a real short list of here's things to think about as I'm preparing to put my will in place. Sometimes I think people think it's way more complicated than it is. I'm considering selling my house and moving, so I can't do a will. Well, that's not true. Right? I'm thinking about, maybe making this one person an agent and not this person. Well, you can change things at any time. So it's not that you've locked it in stone and can't update it. There's really no reason to wait. But as you think about getting prepared to do this, we wanted to give you a list. So just a will, at its very basic core, is you saying what you want to happen when you pass away with your stuff.
Yep.
Very simple.
Yep.
And so you need to think about, are there any specific bequests that I want to make? Do I want one child to get the home? Do I want one child to get, this piece of property, this car, this bank account? If you have any specific bequests, that needs to be listed. You need to list who would get personal property. So tangible personal property items like your household goods, your furniture, your jewelry, your guns, your golf clubs. Who's going to get that? That may be just all kids in equal shares.
Yep.
And that's fine. We don't have to list that out more specifically at this time. Your will can just say, all my personal property goes to kids in equal shares. Yep. Then our residuary, like we kind of talked about. Everything else in your estate at the time that you pass that's not given specifically to somebody needs to add up to 100% and say, these people will receive what I'm, at the end of the day, what's left in my estate. So that could be home, proceeds from the sale of the home, that could be bank accounts, that could be whatever ends up in your estate. And a lot of times people will think, well, I listed everything specifically.
No.
I have nothing left. You will end up with something in that residuary.
Texas unclaimed properties. I mean, there's always something.
There's always something as silly and small as a refund on your supplemental insurance that's $200. Sometimes if you were in a car wreck, you have an outstanding check coming from insurance.
Yeah.
I've had multiple times where someone was getting a new roof and they passed during the insurance period. Well, the insurance is going to pay the estate. So that needs to be caught somewhere.
Heaven forbid your financial advisor or your bank has lost the beneficiary forms on
Yeah.
accounts. I've seen and heard of those situations. Things happen. Places burn down. Records get wiped. And suddenly what you had done and taken care of that would have passed outside of probate suddenly can't. And everyone's looking to say, okay, well, let's look at the will.
Right. So making sure that you have something that adds up to 100%, and then it can be really simple, but you do need to think about if one of these residuary beneficiaries dies before me,
Absolutely.
what happens to their share? So a very common will might say, I leave all to my spouse. If my spouse has died before me, in equal shares to my kids. If any kid has predeceased me, then per stirpes to their descendants, which would be their share remains and goes to your biological or legally adopted grandkids. So that should all be included in your will. Whether you realize it or not, it's in there, but you want to make sure that you've made a conscious decision about what happens in those scenarios.
People, I think don't want to rock the boat, but of course by not rocking the boat, then you're locked into Texas law. And if you're going to get it done, what you need to get done, better today than tomorrow. I promise you, at the hospital, on our deathbeds, bringing in witnesses, not ideal. It's much better, much sounder to do it in advance if you can. You need to get it done early. Don't put your family or loved ones in a situation that's ripe for controversy.
Yeah, absolutely. And one thing we've not mentioned at all here is just the legal capacity to put a will in place. Yeah. You have to, at the time that you are doing your will, know your property, know your family, and understand the disposition that you're making. So if you have some capacity issues, you may not be able to put a valid will in place, so you may have waited too long. So that's important to do it the first opportunity to get it done. The other thing you need to list in your will is an independent executor.
Yes.
And list a couple of those so that that person has the authority to probate your will, handle the disposition of your estate, and take care of anything that needs to be done at the time.
Yeah, some people just love that procrastination because they can't decide those last few details, and I'm like, don't let perfection be the enemy of good enough. Better to have something that's good and solid and takes care of 99% of your stuff the way you want it right now than to overweight or wait too long to get it to perfection. You procrastinate, the law writes it.
Right.
Texas will
Yeah.
write it.
Absolutely. You need a valid will, and let's say that you're out there and you have a will that you tried to do on your own. Please take it to a lawyer and let them review it. Chris and I do that frequently. We don't do it for free, but you can bring your will that you've created, get someone to review it, and tell you whether it's valid or not and what you need to include in there. Now, you may walk out of there hiring the lawyer to do it because you probably should, but you need to get it reviewed. Don't sit on that. The other thing that I would want people to know is ask, when you have a lawyer draft your will, ask them what happens if they need to make a change. Yeah. So for Chris and I, we charge very little and sometimes nothing if you need to update an executor. So if you've come in and done your plan with us and 6 months later you need to make a small change, you're not paying for a whole new set of documents. You already have them and you're making a small change. So don't let that scare you. You can put something in place. You can make regular changes to it. Now, if you start calling us all the time, we will charge you for it. But you can make changes. So please don't let that scare you. And it's not usually starting from scratch if you've already got a good document in place. But please, please, please make sure that you have a validly done will that can be probated at your death to protect your assets for your beneficiaries.
Yeah, don't make us deliver bad news to your surviving loved ones, because that's basically the position that we have to be in when we meet with the spouses and we meet with the kids in those situations. We are never delivering good news if you don't have a will.
That's right. So the answer to the question of the video, do I need a notary to make a valid will? The answer is no. You should probably have one with your self-proved affidavit that you did in a lawyer's office that brought with them the witnesses and the notary, so you just need to bring yourself. That would be the best case scenario that you have done it correctly. So anyway, thank you so much for joining us, guys. We'll see you next time. mean, I think it stopped recording there.
Hmm?
I think it stopped recording, but
It's definitely spinning a bunch. What do they watch?
I don't think so. Look at that. Trim your video.
Probably need to do that. On that one.
Right at 30 minutes.
Wow.
Okay, I think that one's fine. I think Facebook is fine. No, that's still happening. Today. Okay, well, that's this video. See if I can figure out how to trim this. Rich says.
Wow. That's as bad as my other ones in the opposite direction.
You look startled, but.
We're starting. Golly. Face made for radio is what I got. Yeesh.
Clip alignment. What does that mean? No.
Maybe movie inspector?
Movie inspector.
Go back to window. I think it's under windows.
Where?
Under windows to your right.
Mm.
And then down. Show movie inspector. Yeah, there's something. You might be able to edit it down there. You can see my hands. I was doing all sorts of dumb stuff with my hands. That's unfortunate.
What is that? Nope.
I'm so tired. What time do you guys take the kids to school?
Rich leaves at 7.
7.